For many immigrants, April 2026 has become one of those moments where every new headline coming out of Washington feels personal. A single piece of news can instantly raise questions about your priority date, your work permit, your green card timeline, or even your long-term future in the United States. And right now, with Congress once again discussing immigration legislation, that sense of anticipation is even stronger. Families who have been waiting for years are asking the same question. Is this finally the moment when something real changes? Or is this just another political headline that sounds bigger than it actually is? The truth is that while a new immigration bill is indeed part of the conversation, understanding what it actually does requires slowing down and looking closely at the details. The bill being discussed is called the Mines Respect for Essential Workers Act, and at first glance it may sound like a major breakthrough. But when you examine its structure, its scope, and its target audience, it becomes clear that this is not a sweeping reform of the entire immigration system. Instead, it is a targeted proposal designed to address a very specific group of immigrants, certain temporary protected status, or TPS holders, who are already living and working in the United States. In simple terms, the bill aims to protect certain TPS recipients from being removed from the country and to create a pathway for them to adjust to lawful permanent residence under specific conditions. This is important, especially for individuals who have been contributing to essential industries, such as healthcare, agriculture, construction, transportation, and emergency services. The bill recognizes that many of these workers have played a critical role in supporting the U.S. economy and infrastructure, particularly during times of crisis. It attempts to convert that contribution into an opportunity for long-term stability. However, this is where many viewers need to be careful. Just because a bill offers a path for one group does not mean it automatically affects everyone else waiting in the immigration system. For green card applicants in traditional family-based categories like F1, F2A, F2B, F3, and F4, this bill does not directly change your place in line. Your priority date remains the key factor, and the Visa Bulletin continues to control when you can move forward. The same applies to employment-based applicants in EB1, EB2, EB3, EB4, and EB5 categories. The numerical limits that govern these categories are still in place, including the annual visa caps and the 7% per country limit that creates long wait times for applicants from countries like India and China. So while the introduction of this bill may feel like a signal of progress, it does not rewrite the system that most applicants are currently navigating. This is where confusion often begins. Immigration news tends to blend different types of developments together, making it seem like everything is changing at once. But in reality, there are three separate layers that immigrants must understand. First, there are legislative proposals like this bill, which represent ideas and intentions from lawmakers. Second, there are administrative actions taken by agencies like USCIS or DHS, which can directly affect policies without Congress passing a law. And third, there is the existing legal framework that continues to govern cases today. If you mix these together, it becomes easy to believe that a proposal has already changed your situation, when in fact, nothing in your case has moved yet. Looking deeper into the bill itself, it sets clear conditions for who qualifies. To benefit, an individual must already be in the United States under TPS at the time the law is enacted, and they must be working in or training for a job in an essential industry or in a healthcare shortage area. This means the bill is not universal, even within the TPS community. It is selective, conditional, and dependent on both employment and location factors. And perhaps most importantly, it is still just a proposal. It has been introduced and referred to committee, which is an early step in the legislative process. It has not passed the House, it has not passed the Senate, and it has not been signed into law. That means it has not changed any application forms, processing timelines, or eligibility rules at this time. Meanwhile, the broader immigration system continues to operate under the same pressures that have existed for years. The April 2026 Visa Bulletin confirms that visa numbers are still limited and distributed based on priority dates. While there has been some forward movement in certain categories, there are also warnings about potential retrogression later in the fiscal year. This reflects a system that is constantly adjusting to demand, but not fundamentally expanding in a way that clears backlogs. For many immigrants, this creates a cycle of hope and frustration, where small movements are celebrated, but long-term relief remains uncertain. Another important detail is that recent Visa Bulletin movements may not necessarily reflect a more generous system. In fact, some of the forward movement has been linked to reduced visa issuance in certain regions due to administrative actions. When fewer visas are issued in one area, those unused numbers can be redistributed elsewhere, creating temporary progress for some applicants. But this is not the same as increasing the total number of visas available.
It is more like shifting limited resources around rather than expanding them, and that distinction matters because it shows that the underlying backlog problem has not been solved. So what does this bill actually mean for the average green card applicant watching this video? The answer is both simple and complex. On a practical level, it does not change your case today. Your eligibility, your timeline, and your next steps are still determined by the current system. But on a broader level, it signals that Congress is still actively debating immigration policy and considering new pathways to permanent residence. That matters because it keeps the possibility of reform alive, even if progress is slow and uncertain. For TPS holders working in essential industries, this bill could be very significant if it eventually becomes law. It could offer a direct route to permanent residence that does not currently exist. But for everyone else, it is more of an indicator of direction than an immediate solution. It shows where some lawmakers want immigration policy to go, but it does not guarantee that this vision will become reality. In the end, the most important thing immigrants can do right now is stay informed and stay grounded. Follow updates carefully, but don't assume that every headline translates into immediate change. Understand the difference between proposals and laws, between political signals and actual policy shifts. Because in a system as complex and slow-moving as U.S. immigration, clarity is one of the most valuable tools you have. And while hope is important, it needs to be balanced with accurate information and realistic expectations.